As President Biden is preparing to address the country about the threats to democracy from the ideology of the extreme MAGA Republicans, the leader of the MAGA movement continues to show his disregard for the very system that allowed him to be president in the first place. In Florida, we are awaiting a decision by a federal judge on whether she will grant Donald Trump's request for a special master, a third party who would review the documents the FBI seized during its search of Trump's Mar-a-Lago estate last month for any privileged material. Federal Magistrate Judge Eileen Cannon, a Trump appointee, ended today's hearing indicating that she would release her decision in a written statement in due course. The judge also said that she would make public the Justice Department's more detailed list of what the FBI seized from Mar-a-Lago. During the hearing, one of the lawyers for the twice-impeached former president tried to downplay the entire investigation of Trump taking countless highly classified and sensitive government documents and stashing them for 18 months in his public golf resort, comparing the documents to, quote, an overdue library book. Kind of doubt that's what our intelligence agencies will call some of America's most closely guarded secrets. Interestingly, though, is what Trump's legal team did not say. Namely, they never disputed the fact that Trump was in possession of these highly classified materials, even after Trump's custodian signed an affidavit in June saying all of the classified material had been handed over. The DOJ argued that approving a special master would disrupt their ongoing criminal investigation, and that's because Trump is no longer president. He therefore has no claim of executive privilege over those documents. And given that Trump's team waited 2 weeks to even file a request for a special master, the DOJ noted it had already reviewed all the documents and set aside those that may be protected by attorney-client privilege. Now, remember, last week, the judge had indicated that she was inclined to approve the request, though she did not say that that was her final decision. Joining me now is Andrew Weissmann, former FBI general counsel and a senior member of special counsel Robert Mueller's investigative team. I have so many questions. I wish I had more time, but I'm going to start with one. And this is just my geeky question. Is there any significance to the fact that the judge is saying she's going to issue a written ruling rather than reading a ruling from the bench? Does that mean anything?
So, Joy, I love geeky questions. I'm a total nerd, so I appreciate it.
Nerds rule.
Yeah. So, I wouldn't put a lot of weight on whether it's oral or written. She could have maybe done an oral ruling and said written decision to follow, but I actually think it's useful for her to take time and think through what she's doing and put it in writing. Either side may try to appeal this, so she's going to want to put, I think, her best foot forward. So I wouldn't put too much stock in the sort of medium that she chooses.
To me, I wonder what is that she's considering. I mean, Trump's own lawyers, Ms. Habba, Alina Habba, on Hannity last night. Let me just play her. This is what Ms. Habba said last night on Fox.
I do have firsthand knowledge, as you know. I have been down there. I'm down there frequently. I have never seen that. I have never, ever seen that. That is not the way his office looks. Anybody that knows President Trump's office, he has guests frequently there. It's just a joke.
Isn't that an admission that he had the documents and that he had them in his office where people visit? That sounds like that's not helping him. What has she got to decide?
Yeah, well, I think in terms of that statement you just played, she has invited herself getting a grand jury subpoena. I mean, she said, I'm a fact witness. I was there. So it just seems highly unlikely that she isn't going to, be in the grand jury to testify. I do think there's one thing to clarify for people that I do think is fair game. There's sort of two privileges that the judge is looking at: executive privilege and attorney-client privilege. The executive privilege, if she were to rule in Trump's favor that a special master could review for executive privilege, I really think that I would expect the Department of Justice to appeal that. It's so off the wall there's just no law to support that position. And Trump's lawyers did a terrible job of coming up with anything to deal with that. But on attorney-client privilege, it really isn't the case that the sort of horse is out of the barn. The government has said there are a certain limited number of documents that may be attorney-client. So the judge could say, you know what? see if the parties agree or disagree, and if you've got an issue, bring it back to me. I don't think it warrants a special master because we're talking about a limited group of documents. In my view, that's why a federal judge is a federal judge. They're supposed to roll up their sleeves and do the work. But at least on the limited attorney-client privilege documents, I wouldn't be surprised and it wouldn't offend me or be shocking to have the judge say that that's something that needs to be brought to the court, or even though it wouldn't be ideal, to say I'll have a special master review that and then report to me.
Right. And so that's helpful. But we know that Trump's own attorneys have acknowledged he had the materials. There's no dispute that he had these materials. And it seems to me that the Presidential Records Act of 1977 is pretty clear that those materials belong to the United States government. So to be clear, the only thing that she could, in theory even, rule might be adjudicatable are things that you said might be something his attorney might have given him that might have been commingled with those documents. Is that what you're saying?
Yep, exactly. So the executive privilege, if he's saying there's executive privilege, the remedy is those belong to the archives. I mean, those are not his documents. Right. So the only thing that could raise a sort of attorney-client issue is if he had personal documents where he was communicating with his private lawyers. Just to be clear, it's not communications with White House counsel, because there's no privilege there. If for some reason those documents existed in what was seized, then there might be an issue and the judge can decide that and the parties are heard. That happens all the time. And that, if this was any other case, this wouldn't be going on.
A lot of this wouldn't be going on. He wouldn't have been 18 months and be able to hold on to top secret documents.